Good afternoon, everyone. My name is Keisha Dupree, and I want to thank you for joining today's webinar. Before the presentation begins, allow me to review some technical notes. If you encounter connection or audio problems during this webinar, please call WebEx Technical Support. We have placed the phone number in the chat box. Today's webinar is being recorded and will be posted on our website. The link is also located in the chat box. The webinar recording should be available by the end of next week. Lastly, at the end of today's webinar, we will have time for questions and answers from the audience. We invite you to submit your questions throughout the presentation by using the Q&A box on the bottom right-hand corner of your screen. We will do our very best to answer as many as possible before we end at 3 o'clock Eastern Time today. With that, I will turn it over to Josh Weber to start the presentation. Thank you.
Good afternoon, everybody, and thanks for joining us. I'm Josh Weber. I'm the Deputy Director for the Corrections and Reentry Division in the Council of State Governments Justice Center, where I oversee all of our juvenile justice work. If you are not familiar with the Council of State Governments Justice Center, we're a national, nonprofit, nonpartisan organization that provides evidence-based, consensus-based advice to all branches of state government as well as local government on how to improve outcomes for youth and adults in the justice system. We do that work through a variety of different programs and initiatives, including a focus on law enforcement, corrections and reentry, behavioral health, justice reinvestment, and juvenile justice and related education and workforce development activities. For the webinar today, I will start in the first section by providing some context and background about why we conducted this unique study and how the study relates to the broader functioning of the early part, front-end part of the juvenile justice system. Second is I'll provide a summary of the key findings of our research study. And then the third section, I'll provide some theories about what explains our research findings, as well as some concrete recommendations for policy and practice improvement that jurisdictions can take as a result of the findings. I'm also pleased to say that we're joined by Monique McDaniels, who is a senior strategist with the South Carolina Department of Juvenile Justice, with whom we partnered to conduct this study. And Monique will be providing some brief comments after the presentation with the South Carolina Department of Juvenile Justice's reaction to this study, as well as some of the reforms that they have been engaged in to try to improve the juvenile justice and education relationship in South Carolina. Finally, as Keisha said, we'll go through everyone's questions one by one, and as noted, we encourage you to put your questions in the chat. So to start out with, juvenile justice systems over the last 20+ years have transformed in a number of significant ways. There's been an almost over 3/4 decline in juvenile arrest rates, such that until recently, juvenile arrest rates were at their lowest level in over 30 years. There's been an over 2/3 decline in the number of youth that are incarcerated. And the number of youth who are detained has almost been cut in half over the last 20 years. In addition, jurisdictions around the country have increased their use of structured decision-making tools like risk and needs and detention screening and assessment tools, the implementation of evidence-based programs and practices, and have also been focused on employing more developmentally appropriate approaches to serving youth in the juvenile justice system. But in our experience, much of these reforms have really happened at the deepest end of the juvenile justice system, really focused on reducing the number of youth who are incarcerated, trying to improve conditions of confinement, and there's been comparatively less focus and less reforms on the front end of the juvenile justice system. In fact, over 725,000 youth are still arrested every year. And it's important to say that only 6% of those arrests are for violent offenses. So almost 95% of all young people that are coming into contact with law enforcement and that are arrested are for non-violent offenses. In addition, over 100,000 youth are referred to court each year for what's known as status offenses. So status offenses are offenses that are only considered a crime because they're committed by youth. The most common one is truancy, But also status offenses include running away, alcohol and tobacco violations, as well as youth who are generally incorrigible. Not only are over 725,000 youth arrested every year, but we know that racial and ethnic disparities in those arrests are pronounced and long-standing. Despite substantial attention in the juvenile justice field to these issues, still, based on the most recent data available, compared to their white peers, Black and Hispanic youth are 5 times more likely to be arrested for a violent crime, 3.5 times more likely to be arrested for a property crime, and 3.5 times more likely to be arrested for discretionary offenses like disorderly conduct and breach of peace. It's really important to take a look at the number of young people, and particularly the number of youth of color that are coming into contact with the juvenile justice system every year, because research has been really clear that system involvement for youth that have a low risk of reoffending is actually likely to do more harm than good. So research has shown that when you compare two similar youth that are low risk, youth who are arrested and or referred to court, versus youth who are completely diverted out of the system, even if those youth who are diverted receive no other services, the youth who are arrested and court involved have a higher likelihood of reoffending, a higher recidivism rate, are less likely to complete high school than their diverted peers, are more likely to suffer from mental health issues, such as trauma and other potential collateral consequences of coming into contact with the justice system. And it's also generally a resource inefficient strategy. Research has really shown that you get the best bang for your buck by focusing on the youth that have the highest risk of reoffending, and that judges and probation officers and service providers should really focus on providing intensive supervision and services to meet those young people's needs. Any efforts to serve youth that are low risk in the juvenile justice system really take staff and resources away from focusing system attention on those higher risk youth, and as research shows, not likely to have a beneficial impact, and actually pulling low risk youth into the juvenile justice system is likely to do more harm than good. So we conducted this study because as we've worked with juvenile justice systems across the country at both the county and state level, we have found that judges, prosecutors, law enforcement, and others have been uniquely concerned about youth school attendance and youth school performance, and that thousands of young people every year are pushed into the juvenile justice system, not necessarily because they're a public safety risk, but because of concerns about their educational progress and their status of completing school. And so we wanted to really take a look at what impact does system involvement have on school attendance and performance. Youth are pushed into the juvenile justice system, youth are often placed on probation, youth can be pushed deeper into the juvenile justice system under the presumption that system involvement and system oversight has a beneficial impact on school attendance and is more likely to get youth to go to school and perform better in school. But we really wanted to take a look at, is that in fact the case? And the broader question of really what role should the juvenile justice system have in addressing school attendance and performance? And certainly in this time more than ever, where there's been a lot of questioning about what role the justice system should play in young people's lives, and particularly the lives of youth of color, one way of looking at that question and the front end of the system is the roles and responsibilities of the juvenile justice system when it comes to education. It's important to take a look at this question because juvenile justice systems across the country have taken on a number of key formal roles and responsibilities related to youth education, again, under the presumption that system involvement is going to help young people's school success. So the first is the United States is one of the few countries in the world where youth can be sent to court for missing school. In about half of states, truancy is still a crime. And really, perceptions and actions around truancy have changed far less compared to other delinquent offenses. So as noted, court referrals are down overall significantly over the last 10 to 20 years. And referrals for almost every single individual delinquency offense And as the chart on the right shows, for almost all status offenses, have declined fairly steadily. But if you look at that blue bar on the chart, what you see is court referrals for truancy over the last 5 years really haven't budged significantly. And in fact, from 2017 to 2018, the most recent year that data is available, actually saw almost a 15% increase in court referrals for truancy, so that over 60,000 young people across the country are referred to the juvenile court for truancy every year. Second is 288,000 youth more broadly are placed on some form of probation annually. Less than 30% of those probation placements in 2018 involved an offense against a person. So the question is, why are so many young people, many of whom who are not necessarily, at least based on their offense, a risk to public safety, being placed on probation? And while there's no national data on that question, our experience has shown that at least some proportion of those population of youth are being placed on probation, either directly or indirectly, because of concerns about their school attendance and performance. Additionally, nationwide, for almost every young person that's placed on probation, school attendance and sometimes school performance are standard conditions of their probation that they have to comply with. Third is because mandatory daily school attendance and performance are often probation conditions, youth can be detained or incarcerated for not complying with those conditions. So fairly steadily over the last 5 or 6 years, about 20 to 25% of all youth who are detained as a result of a technical violation. Similarly, about 13 to 15% of all youth who are incarcerated long-term in state custody are incarcerated as a direct result of a technical violation. Now, the reasons for those technical violations, again, are not really tracked in data at the national level. And even many, if not most, counties and states don't track the reasons for those technical violations. But in our experience, and we were able to find at least one research study that showed that failure to comply with school-related probation conditions was a common reason for technical violations and for subsequent confinement. So juvenile justice systems across the country have taken on a number of formal responsibilities related to education. Youth are placed in the juvenile justice system because of education reasons, and youth can be placed deeper into the juvenile justice system because of education reasons. But there's some real gaps in the research in understanding whether that's actually an effective practice. We do know, and multiple studies have been conducted that show that youth who are arrested compared to their similar peers in terms of risks and needs who are not arrested, that arrest actually has a negative impact on their likelihood of high school completion. And also research has shown can even impact their long-term post-secondary credential attainment. Research has also shown a little bit less research, but research studies have been conducted that show that youth who are incarcerated, again, compared to their similar peers, are less likely to complete high school. And yet there was not a single research study that we can find that looked at the relationship between being placed on probation and changes in youth school attendance and school completion. And that's really important because placing youth on probation is the single most common juvenile justice system intervention used across the country. 10 times as many youth are placed on probation every year as are incarcerated, at an estimated cost of $2 billion each year. And so understanding what kind of impact probation has on youth school attendance was really a major gap in the research and the gap that our study was looking to fill. So next, I'll talk about the methodology for the study and provide an overview of the key findings. So in order to conduct this study, we partnered with the South Carolina Department of Juvenile Justice and were able to obtain data from South Carolina's integrated data warehouse. One of the reasons why this kind of study has never been conducted before is, as many folks might know, trying to get school data can be extremely difficult. Well, South Carolina has the benefit of having an integrated data warehouse that has both juvenile justice data as well as education data. And so we were able to get data from that system on a cohort of about 11,000 students who attended public high school in South Carolina and who came into contact with the juvenile justice system. And there were two populations of youth in that study. The first is youth who were involved in the juvenile justice system, but then were diverted from formal system involvement. In South Carolina, like in many states, diverted can mean a lot of different things. Some of those youth were diverted to formal system-run diversion programs and still had some form of system supervision, while some of those youth were diverted really out of the system and received services. The second population was youth who were placed on probation as a result of their juvenile justice involvement. So we were able to look at the school attendance for both of these populations, the diverted youth and the youth placed on probation population. First, we were able to look at their daily school attendance in the year prior to them coming into contact with the juvenile justice system. And then we were able to look at their attendance in their first year of system involvement, whether that was through diversion or through placement on probation. So essentially what our study does is examine the change in attendance from the first year to the year of system supervision. In the meantime, we were able to control for a variety of demographic and school differences. So we could try to isolate the impact that being involved in the juvenile justice system was having on these young people. So we were able to control for race and ethnicity and gender and age, the offense that youth have committed, the number of prior offenses, the county they came from, as well as some school demographics. The reasons why youth don't attend school are complicated, so obviously you're not able to control for every factor that might influence that, but the goal was to control for as many factors as we could to really try to isolate the impact of system involvement on attendance. Finally, as a complement to the data analysis, we conducted a series of focus groups with stakeholders in South Carolina, including law enforcement, school resource officers, probation officers, judges, prosecutors, public defenders, service providers, education staff, Department of Education staff, to better understand the policies and practices that impact youth educationally who get involved in the juvenile justice system, and what some of the gaps and challenges in the relationship between the juvenile justice and education system are. And that really informed our theories about why our findings resulted the way that they did. And that work is not just from focus groups in South Carolina, but really ones that we've done on similar issues with juvenile justice systems across the country. So what did we find? So our first key finding is there's good reason for jurisdictions to be concerned about the school attendance of youth who come into contact with the juvenile justice system, because they miss a really substantial number of days of school. So what we found is in the year prior to becoming involved in the juvenile justice system, diverted youth missed an average of 26 days of school, and youth who were ultimately placed on probation missed an average of 42 days of school. So out of 180 school days in South Carolina, that means, for example, that probation youth on average missed almost a quarter of the school year in the year prior to the system involvement. Furthermore, beyond those averages, a quarter of the youth who were placed on probation missed almost 60 days of school or more, so over a third of the school year. So really a substantial number of missed days of school, and right to want to try to address that situation. But probably the main finding from our study is contrary to what prosecutors and judges and law enforcement and others might expect. The school attendance of youth who were diverted or placed on probation did not, in fact, improve in the first year of their system involvement, despite that really poor attendance prior to the system involvement. In fact, their attendance got worse. So what we found is in the first year of system involvement, both diverted youth and youth who were placed on probation, their attendance declined by 5 additional days. Now, 5 days might not sound like a lot, but one, it is a statistically significant difference. And two, again, the presumption by placing youth in the juvenile justice system was that their school attendance would improve. And in fact, we found quite the opposite, that potentially that system involvement actually made things worse. Our third key finding was one thought was that the reason why youth school attendance in their first year of system supervision did not improve is maybe school attendance wasn't a significant focus of juvenile probation and others for all youth who were referred to the system. So we took a specific look at youth in South Carolina who received a truancy court order. So this is a court order specifically that mandates youth to attend school every day and imposes potential consequences like further system involvement, which could include more intensive probation or even confinement in detention or incarceration if you don't improve their school attendance. And also presumably along with that, some support and services from the system to improve their school attendance. But what we found is, again, controlling for all sorts of factors. So looking at two groups of similar youth who had those school attendance orders and presumably school attendance was a focus of system intervention, their school attendance did not improve any more than their peers who did not receive a school attendance order. Fourth and final finding is we took a look at whether being placed on some form of system supervision had a disproportionate impact on any particular demographic groups. Did anyone's attendance improve or suffer significantly? And what we found is that the biggest impact in terms of system involvement was actually based on young people's age. So youth who were under 15 years old, from the initial year to the first year of system involvement, their attendance only declined by 1.5 days. But youth who were 15 years and older saw a much more significant decline. So from the initial year to the first year of system supervision, their attendance actually declined by 7.5 days, so a 6-day difference. It's hard for us to know and not able to really tell in the data why older youth were much more significantly impacted in terms of their attendance by system involvement. But we do know from research nationally that school absentee rates increase as youth get older. And so potentially system involvement could exacerbate the reasons why older youth more generally attend school less, drop out of school, and feel less engaged in school. And so maybe system involvement accelerates a process that was already underway. So next I want to go through potential explanations for these findings. Why does system involvement in our study really add to these existing studies that shows that not only does system involvement, in this case probation, not positively impact youth attendance, but why does it apparently make attendance worse? And we identified 3 key reasons that might explain our research findings. The first is, while there's been increasing attention to the roles and responsibilities of juvenile probation and to orienting those around more positive behavior approaches, in general, most county and state probation agencies are still fundamentally oriented around supervision, compliance, and sanctions functions, which research has really shown don't really get at and address and promote long-term behavior change in adolescents, such as school attendance and performance. And there's a number of different nuances to this. The first is that the reasons why youth don't attend school are individualized and complex. Some youth might not attend school because they have a learning disability issue. For some, it might be concerns about negative peers and gang involvement. Some youth just might not be interested in school. Other youth, it might be an economic issue or a family issue. And so an overall system response that just focuses on monitoring or the threat of sanctions doesn't really get at those kinds of complicated and individualized reasons. I think the current school environment where students across the country are challenged by a mix of in-person, online, hybrid mechanisms, and systems across the country are trying to figure out how to manage youth attendance and school behavior in this complicated environment really just reinforces that idea that even now more than ever, it's impossible to know what's going on with youth and their families and their home life and their health situation and what might be driving their lack of school engagement. related is that it's unreasonable to ask your average probation officer to have the skills or the expertise to really assess and address those root causes for youth's lack of school engagement and their underlying youth learning needs. That's not what probation officers, that's not their core job and their core mission, and really typically aren't set up to be able to do that effectively. More generally, the tools that are readily available to most probation agencies, which is court mandates, oversight, compliance checks, and sanctions if youth don't comply with court-ordered conditions, are not likely to be effective at getting at those root causes and promoting long-term behavior change. And so really, as we've shifted in juvenile justice systems to a more risk-need responsivity model of trying to understand what are the underlying reasons driving youth delinquent behavior and matching them with appropriate interventions accordingly, we likely need the same approach for getting at the reasons why youth aren't attending school. And many juvenile justice systems are just not set up to do that very well. In addition, we've seen a number of common practices both in South Carolina, but really across the country of probation agencies that could also have a deterrent effect on youth school attendance. So first, in many jurisdictions, it is still common practice for probation officers to visit youth while they're at school. And we heard Youth and Families in South Carolina tell us and across the country that can make them feel stigmatized. Inevitably, teachers find out, school administrators find out, their peers can find out, and make them not want to attend school when others know that they've been involved in the juvenile justice system. At the same time, being placed on probation often comes with a lot of requirements. That can include court hearings and progress appointments, other mandatory probation appointments, service appointments, community service appointments, and many of those often are scheduled during school hours. And so just the nature and the logistics of being under system supervision can force youth to miss school time and also parents to miss work in ways that interfere with young people's school engagement. The second potential reason why system involvement might have more of a detrimental impact on youth school attendance is the act of youth becoming involved in the juvenile justice system by itself can change the way that youth view themselves and also the way that other people view young people and treat them, which is known as the labeling effect. And so two manifestations of that. First, youth who are arrested and placed on probation, even if they don't have a history of juvenile justice system involvement, even if they've tried to stay out of trouble, by becoming arrested and placing them in the juvenile justice system, they can come to see themselves as delinquent. We know that adolescents are very impressionable. They're in a process of trying to form their identity. And so something significant and traumatic like an arrest can really have an impact on shaping their self-image and how they view themselves. And the result can also shape how they act. So even if youth were consistently engaging in school, if they come to think of themselves as a delinquent, they might associate with negative peers and they might end up skipping school more. So unfortunately, the act of trying to bring the youth's challenges to someone's attention, and often as a way of getting them services, can have the opposite of its intended effect. At the same time, system involvement can also cause other people to see youth as delinquent and to treat them accordingly. So when a youth becomes involved in the juvenile justice system, that can change how their family members think about them and treat them, their teachers, mentors, coaches, other positive peers. And so again, even though system involvement is often being used as a way to connect young people with needed services and supports, the act of involving them in the juvenile justice system could have the opposite of its intended effect by actually straining or severing the positive connections that youth have that we know are really critical to school engagement and success, and just more generally keeping youth out of contact with the justice system. The third reason relates not just to the juvenile justice system, but the policies and practices of schools. And so in our focus groups and conversations with folks in South Carolina, we heard of schools imposing a variety of sanctions on youth who become involved in the juvenile justice system that are likely not just to impact their school engagement and their attendance, but a host of other positive youth outcomes. And it's really difficult to sort of quantify or know how prevalent some of these policies and practices are. As many folks know, one of the challenges of trying to influence school policy and practice is often at the local level. And so it differs by district and often even times within district from school to school. But these are just some of the policies and practices that we've heard, not just in South Carolina, but in jurisdictions across the country. So first, in many jurisdictions, school personnel are not only able to receive notification of youth's juvenile justice system involvement, but in some cases are even states or locales require law enforcement or the courts to notify school personnel when youth become arrested, and school personnel can have access to youth's confidential records. And certainly understandable if youth commit a serious offense or a violent offense, and one that involves on school grounds or school personnel or students. But most often, these kinds of policies don't make that distinction. And almost any arrest can be shared. As we talked about earlier, 94% of all arrests are for a nonviolent offense. And when this information is shared with school personnel, as noted, that can really impact how that personnel, how teachers, inevitably when students find out how they treat youth, how youth feel stigmatized. And so broad policies that allow for sharing of youth juvenile justice involvement can have a negative impact on their willingness to attend school. We also heard examples of youth being barred from attending classes before they've even been proved guilty of a crime. So rather than being innocent until proven guilty, the opposite is just when youth are arrested and charged with an offense, even before they've been adjudicated by the juvenile court. We heard schools not allowing youth to go back into the classroom, requiring them to participate in online or other kinds of learning until their case was resolved. Perhaps most frequently, we heard that a youth becoming arrested and or placed on probation in a number of schools was an automatic reason to suspend or expel young people. And we know from a lot of research that suspensions and expulsions disproportionately impact youth of color, and also have the unintended effect of pushing youth into or deeper into the juvenile justice system. And in many cases, those suspensions and expulsions happened in just sort of a summary notification way, where the youth received a letter in the mail, so without a formal hearing, without parental involvement, and almost never without legal representation or formal due process. Now, given the impact that suspension and expulsion can have, not just on youth school attendance, but on a variety of longer-term life outcomes, disturbing to see both youth being automatically suspended or expelled without a more individualized consideration of their offense and of the risk they pose to school safety, and also that those important decisions are happening without due process. For many of those young people who are suspended or expelled, a number of schools require those young people to attend alternative schools. Now, alternative schools can be beneficial, but the research is really mixed on alternative schools, particularly when those alternative schools are for quote unquote special need or troubled students. And what we heard from stakeholders in South Carolina, as well as from other states, is those schools can have lax academic standards. And youth who attend alternative schools don't receive public transportation, and that they're barred from participating in extracurricular activities like sports or clubs. Now, again, looking at sort of all of these policies and practices, even though they may be driven by some public safety concerns or by some good intentions, the result of all of these efforts is, again, to disconnect young people from their home schools, from whatever positive peers or positive adults or relationships or pro-social activities that they've established. And again, we know that vulnerable students, struggling students, students who are involved in the justice system research has clearly shown that it's actually the opposite that makes the most difference, right? These young people need more support, more services, more pro-social adults and peers, not simply just to attend school, but research has shown that that kind of positive support has a long-term impact on keeping them out of the juvenile justice system. So based on this research and based upon the previous research that's really now shown sort of consistently all levels of system involvement, from an arrest to probation to incarceration, have a negative impact on youth school attendance. A couple of recommendations from jurisdictions that are really looking to rethink the roles and responsibilities of the juvenile justice system when it comes to keeping youth in school and on track. So the first is, as mentioned, about half of states still have a statute that has truancy as a crime. Even in a number of states where truancy is no longer a crime, there are still ways that youth can be referred to court for missing too many days of school, whether that's through a civil case or a child welfare case. And so the first recommendation is to really rethink whether the juvenile justice system or the courts writ large should be in any way responsible and really are the most effective tool for improving youth school attendance. Instead, we would recommend that the primary responsibility in jurisdictions for improving youth school attendance should be agencies whose mission is focused on education and youth development and not public safety. So if the goal of the juvenile justice system really is to protect public safety, then the juvenile justice system should really serve only those youth that really represent a risk to public safety, and youth that have a low risk of reoffending but have needs such as concerns about their school attendance, their school performance, or other kinds of needs. Those young people really should receive services and supports from organizations. It could be community-based organizations, schools, as well as social service agencies, whose core mission and responsibility really is to promote young people's education and well-being. And so part of that is also designating the resources accordingly. So whether those resources are with schools, whether those are resources for truancy interventions with community-based organizations, is to really rethink whether that should be law enforcement and juvenile justice agencies' responsibility, and who else has really the expertise to intervene with youth most effectively. Related to that, unfortunately, despite long-standing concerns about young people's school attendance, there isn't a lot of really well-done research on effective truancy interventions. Most of the research on truancy interventions has shown that there are a number of possible modalities that could have an impact, but none of those have really been shown to have a significant impact on reducing truancy. And when we're talking about the kind of young people that we looked at in our study that are missing on average 30, 40, 50, 60 days of school, programs or interventions that really only improve attendance by a few days aren't nearly sufficient. So our recommendation is really to have the same approach to truancy as you would to reducing delinquency, which is really trying to focus truancy interventions on assessing and addressing what are the underlying reasons for individual youth school engagement challenges and tailoring interventions accordingly. So if it's a learning issue or a gang issue or a family issue, interventions really should be tailored to those individualized reasons and should be based on services that address those reasons rather than compliance and sanction-based approaches that aren't going to get at those root causes. The next recommendation is for probation agencies to really rethink the common practice of having standard education-related conditions of probation for almost every youth that's placed on probation. It's obviously not a bad thing to want youth to attend school, and again, our research sort of affirms that there's good reason to be concerned. But again, the question is whether conditions of supervision related to education really are a helpful mechanism, and instead that if youth violate those conditions, can those conditions inadvertently have the impact of pushing youth deeper into the system. So instead, we would really recommend that those conditions are only imposed if school-related issues are a direct cause, an underlying cause of youth's delinquent behavior. Otherwise, the other consequence is that probation officers often spend time trying to get school records, trying to talk to school personnel to check up on their attendance, and that might take them away from more important responsibilities and a more important focus on what are the actual reasons that you came into contact with the juvenile justice system in the first place. The next recommendation is whether it's youth being placed on probation or hopefully interventions outside of the juvenile justice system, jurisdictions should be realistic and establish developmentally appropriate goals for youth attendance improvements. So a youth who has been on average missing 30, 40, 50, 60 days of school is not realistic to suddenly ask them to attend school every single day and to exert consequences such as detention or other punishments if they don't suddenly improve their attendance. Research has also just generally shown that with adolescents that they're more swayed by incentives than they are by sanctions. And so goals for attendance improvements should be realistic, and incentives really rather than punishment should be the primary motivational tool. That doesn't mean that youth shouldn't be held accountable, but it should be, again, a developmentally appropriate system of graduated responses paired with those incentives, and really a partnership with youth and families to try to get them to achieve those goals. Next, for probation agencies, really an encouragement to eliminate probation contacts while youth are at school. That those probation contacts are likely to do more harm than good, even when efforts are made to keep those confidential. School personnel and other students inevitably find out, and that can really have a stigmatizing effect. Likewise, for probation and court appointments to be after school hours. Sort of an irony of youth being placed on probation in part for school-related reasons, and then probation and court appointments directly interfering with the time that youth should be attending school. So obviously operational implications there for probation officers, for courts about having to operate in non-traditional hours. But if we really want to keep youth in school to the extent possible and also be as convenient as possible for families, those kinds of requirements should not interfere with youth school attendance and responsibilities. Next two recommendations are really focused on schools. And again, in many jurisdictions, school policy and practice is incredibly local. And so it can be really hard to impact a jurisdiction-wide school practices. But schools have a really important role to play here. Is juvenile justice systems can do the best they can to have a more research-based, developmentally appropriate approach. But if schools are still imposing sanctions on youth who become involved in the juvenile justice system, then that's going to have an impact on pushing youth out of school as well. So really encouraging potentially statutory changes or administrative changes that limit or restrict the automatic imposition of sanctions on youth who become justice involved, particularly suspensions and expulsions. Again, such actions might need to be considered if a youth is a direct threat to public safety, if the victim was a fellow student or a teacher or school personnel, and there are good reasons to be concerned. Then a suspension or an alternative school placement might be an appropriate option. But again, should be an individualized approach, and no youth should automatically have to suffer consequences. Really should be an individualized education and school placement plan to make sure youth are connected with pro-social adults and peers and activities as much as possible. And then finally, whatever school justice involved students are in, whether that's their home school, whether that's an alternative school, these are among the most vulnerable and at-risk students in a jurisdiction. Is rather than viewing their justice involvement as a signal to sort of remove them from the supports they need, really should be a signal to schools, education systems, that they need even more support and services. And so those youth should get the same quality and standards of education, same connections to positive adults and peers, and same ability to participate in pro-social activities inside and outside of school as everyone else, and even more so to help improve not just their school attendance, but to keep them out of further contact with the justice system. So with that, I'll stop there. Just want to make sure folks connect and review the report that we released that provides a more detailed summary of these findings, as well as the two infographics, interactive infographics we released that really help jurisdictions pose challenging questions about current approaches and also have recommendations. I also want to flag that we partner with jurisdictions to assess their juvenile justice systems through our IOU Improving Outcomes for Youth initiative. And that's going to increasingly have a focus on these front-end juvenile justice system issues, including diversion, including the engagement of law enforcement and community members, and also a focus on juvenile justice and education roles and responsibilities. With that, I want to turn things over to Monique McDaniels with the South Carolina Department of Juvenile Justice to provide some of her reactions and to talk about what the department has been doing to reform efforts. Monique?
Thanks, Josh. Good afternoon, everyone. We truly appreciate the opportunity to be a part of the study and also concur with the findings, of course. The agency has worked for the past few years with a lot of community stakeholders, with our state legislators, especially in the Senate, around juvenile justice reform. And so we're very committed to the process. We appreciate the in-depth information that the study provided, as well as the timing of it. South Carolina began to really tackle juvenile justice reform this year before the pandemic hit, and so we were stalled by that. So we're really encouraged that our senators are going to take up the reform bill at the beginning of the legislative session that will begin in January. And some of those recommendations that we have made along with other stakeholders is to essentially do what you stated in your report: stop punishing young people for being young people. Taking a real look at those that are a threat to public safety, and let's focus on them. Our data and research has shown us just internally that about 10% of the young people that touch our detention center that are detained should in fact probably be in some type of level of commitment for a period of time, but not for multiple years. We can go in and do a really great job with them in just a short amount of time. But again, those youth that we serve, which is about 75% are on probation or served in the community, we see a lot of the same negative effects, the stereotypes, just the lack of being able to be engaged. And so we've asked for our state to really consider uniformity when it comes to diversion and intervention programs. Right now, we have 16 circuits throughout our state, and each of those circuits operate very differently when it comes to either our prosecutors or our family court judges. And so we've looked at, can we bring some uniformity, because a county or a circuit that may not be as resource rich as another, a young person may not get the same opportunities as someone else in another neighboring area. And so we've asked for uniformity. How do we do that? How can the state support us in making sure that every young person gets the same number of bites at the apple, and not just because you are in an affluent county or district? And so we've taken a look at that. One of the things that our agency has just recently done in the last year is that we've signed on to become a part of the JDAI platform. And so we're looking at, how does that impact us? How are we stopping young people from even coming into the system at all? And so we're really excited about the opportunities that will come from that. We've looked at, of course, our responses. Some of our recommendations, just like you all pointed out, was for the education system, right? So how do we do more interventions within the school system opposed to recommending them for any type of involvement with the justice system? Oftentimes that, like you stated in your report, we found that a lot of these are social service issues. And so one of our recommendations during our reform efforts and work sessions was that we are able to display that the school, social services, the families have all had an opportunity to intervene with this young person on multiple occasions, opposed to them just automatically receiving a referral to be involved with the Department of Juvenile Justice. And so those are some of the broad stroke things that we have taken a look at. Of course, status offenders is a big topic nationwide, and we've looked at the same thing. Let's stop punishing young people for things such as truancy, incorrigibility, things that may only get a fine if you were an adult. And so, of course, South Carolina raised the age last year. And so we're excited about that opportunity, but we need reform to go along with that so we can stop having young people, of course, penetrate the system. So again, I'll just say thank you all for the opportunity. Thank you for the report. We've clearly shared it with our stakeholders. We're hoping that this is something that will come up as a topic or a key point when we begin to tackle reform again in South Carolina at the beginning of the year with our legislators. So we're just excited about what the report has shown, because of course we need to focus and wrap our young people with as many services as possible.
Great. Thanks so much, Monique. I think Monique's comments really helped to tie in, again, sort of going back to that context and background, how this study relates to a larger rethinking about the front end of the juvenile justice system. I think, as Monique articulated, what happens in South Carolina in many cases and what we've seen across the country is that youth are pushed into the juvenile justice system, not because they're a public safety risk, but because of a way of getting those young people connected to services. And because oftentimes schools don't have the resources, or in some cases don't want to take the responsibility, or there's no other agency or other formal system to help address the needs of youth that are truant and really understand what's driving their school engagement challenges, and address the needs of other youth that have a low risk of reoffending, and figure out the best way to address those needs. And so the lack of a formalized alternative system has really expanded the role of the juvenile justice system in being a service provider. But what our research shows, in addition to the other research, is that juvenile justice involvement comes with negative collateral consequences, not just a potential impact on youth school attendance, but really also can increase their recidivism rate, as mentioned, can have mental health and other kinds of implications, lifelong collateral consequences of having to report an arrest or court involvement that can impact employment and other educational activities. And so rethinking the role of the juvenile justice system as it relates to education, it's really an encouragement to really think about the broader front end of juvenile justice systems in your jurisdiction, and where there might be opportunities to build alternative service systems and alternative pathways other than using the juvenile justice system to meet these needs. So with that, I will go through folks' questions, and feel free to put additional questions in the chat.
Great. Thank you, Josh and Monique. So a couple of questions have come in about the study itself, and then a couple about recommendations. So first, in terms of the study, did the study follow or compare youth who may have been in trouble but did not get juvenile justice contact as a result of their behavior?
Yeah, that's a great question. So that's a study that we would have loved to be able to do, is have a comparison group. That's not the data set that we had available to us. It really was just this data set of public high school students who then got in trouble and became involved in the juvenile justice system. Those kinds of comparison studies can be difficult to do. That certainly is a next step in this area. Some of the other studies that we cited that looked at the impact of an arrest and that looked at the impact of an incarceration did have comparison groups. So, really we see our study sort of plugging that hole around the impact of probation, but really now part of this larger portfolio of research, whether it's comparison group studies or studies like ours, that really raises a question about system impact doing more harm than good when it comes to school attendance and completion.
Great. And a couple of questions have come in about the role of schools in terms of supporting young people who may have attendance issues or may be truant. How do you get schools on board with being the ones responsible for supporting those young people or intervening? And what are some examples of things that schools can do to better support those young people rather than getting them involved in the juvenile justice system?
Yeah, so good questions. And as noted, a real challenge, because in many states, school policy and practice really is determined at the district level and often the school level. But the first step would be looking at what's in statute. So some states and many folks might not be familiar with the statute, but there is often statute that pertains to diversion and schools' roles and responsibilities, generally in the juvenile justice system, but also around truancy. There is often statute about what information can be shared with schools. And so while it might be difficult to establish statewide guidelines or statute, first looking at what it is in statute, trying to make sure that it is realistic, developmentally appropriate. And then in a number of states that we've worked with, as well as other states that have reformed their efforts, they have established statutory provisions that as a first step require schools to engage in certain planning and interventions before making a referral to the juvenile justice system. So our research and other research would suggest even going farther and not allowing the juvenile justice system to be used at all for school-related issues. But as at least a first step, states and counties can establish statutory or administrative provisions that require schools to, some states have said you have to put together like a truancy board or some other kind of local advisory group to review truancy cases, that there has to be a truancy intervention plan that's developed and implemented within the school at the local level using community-based services and supports. In many jurisdictions that we work with, there are actually a lot more supports and resources than most folks know about, right? Often the complaint or the challenge from schools or others is there isn't sufficient services. But when we've done service mapping and scans with jurisdictions, we find that between the juvenile justice system, the education system, the child welfare system, the behavioral health system, and more grassroots kind of community-based organizations, there's often more supports than folks realize. So I think a first step is requiring, as well as supporting schools to take interventions, collaborative planning efforts, draw on local resources before, and demonstrating that those efforts really have taken place before you can be referred to the juvenile justice system. And again, it's services and support focused rather than sort of compliance or sanctioned focused. And so those partnerships with community-based organizations with schools are really critical.
Great. We only have a few minutes left, so I'm going to try and combine a couple questions that we've received about the role of the juvenile justice system and the role and how probation can use incentives to support young people on probation who may have issues with their conditions, or to incentivize positive behavior. Are there examples, Josh, that you can provide of that? And then related to that, are there jurisdictions that you know of that have removed those education-related conditions from their probation agreements?
Right. So great questions. So this is an area that jurisdictions are just beginning to explore now. You may have seen, whether it's from us or from the Annie Casey Foundation or other sources, sort of encouragement for jurisdictions to really think more broadly probation, the role of juvenile probation, and try to position probation more as focused around positive youth behavior change. And so while there are a number of jurisdictions that are moving in that direction, it's really initial steps. And this fundamental question around probation conditions is not one that a lot of jurisdictions have tackled. There are jurisdictions that have tried to limit the number of conditions, that have tried to make the language of those conditions more developmentally appropriate, because oftentimes youth and families don't even understand what's required of them in the system. Or if there are 30 conditions that a well-supported, a well-resourced youth could barely comply with, any adolescent, let alone an adolescent who's facing a number of challenges, to really try to streamline those conditions. But there's been less examples of jurisdictions taking that bigger step back and more fundamentally questioning, do we need conditions at all? What's their benefit? And if so, what kind of conditions, and what our response should be? So that is a real step for jurisdictions to take. There's been a lot more efforts to develop incentive and graduated response systems. So a number of states, for example, we're working with Colorado right now, require statewide development of graduated response systems that include both incentives and sanctions, so that even if these conditions are in place, that a technical violation and that incarceration as a result of a technical violation. So for example, we're working in North Dakota and they're looking to pass legislation that would restrict any youth from being detained or incarcerated directly as a result of a technical violation. So really trying to use both those technical violations and impose sanctions on youth for them as a last resort. And often the question gets asked, well, how do you develop incentive systems? And our encouragement, again, sort of consistent with a lot of what we've been saying, is to use an individualized approach. The best incentives are going to be that individual youth and families identify together in partnership with probation officers as the things that actually motivate and respond to them. And so really both establishing the formal incentive and graduated response system, but then individualizing it as part of case planning and case management with individual youth and families, I think is a really important step, not just to how to respond to probation conditions, but overall trying to get youth on the right track.
Great. I know we're out of time, so maybe I'll throw out one last question. I don't know how we can get away with not having a COVID question during this context, and we have a couple. If you could talk just very briefly about how the implications of COVID-19 for this work in terms of the role of education, the role of the juvenile justice system, how they can interact with young people in this virtual COVID environment.
Yeah, so obviously a very uniquely challenging school year, and as I mentioned, we've heard from a number of jurisdictions, and it's been on the news that jurisdictions are wrestling with how to monitor school attendance, often in a virtual environment, how to respond to youth school behavior. And if anything, we think that the current this current challenging situation just reinforces the importance of an individualized approach, right? If youth are not regularly attending school, the reasons are even more complex than they've ever been. Maybe it's an issue with online learning and challenges with engagement. Maybe it's a technology issue. Maybe it's a family issue and families not being able to provide supervision. Maybe it's a health issue. Just again, sort of reinforces now more than ever the reasons why kids aren't going to be engaging in school is really complicated. And so not having knee-jerk responses, not having sort of the automatic use of sanctions, but really trying to have a more individualized response that understands what's driving those particular school engagement challenges for those individual youth and responding accordingly. I guess the other sort of element of this is, as a result of the pandemic, what we have seen from juvenile justice systems across the country, at least for the first few months, was a real scaling back of youth being arrested for low-level offenses, youth being detained for sort of less intensive public safety reasons, to the point where jurisdictions are asking themselves, well, if we could do that now, maybe those are policies and practices and approaches that we should sustain moving forward. And so, the expression of not letting a crisis go to waste, those kinds of changes in how systems function really should be encouraging jurisdictions to take that larger step back and think again, particularly about the front end of the system. And if there weren't, really negative ramifications for not arresting those youth or not detaining those youth for truancy, for low-level offenses, for things that don't rise to public safety reasons, could those be changes that are sustained and that could have a significant impact, not just on those youth outcomes, but really, again, focusing the juvenile justice system on those young people that are a public safety risk. And really, this part of the broader conversation that the country's having, not just about COVID, but about the role of the justice system in people's lives. In many ways, these two things are sort of coming together to encourage juvenile justice systems to rethink who they're serving and what's the most effective way to do so. So with that, appreciate people staying a little late. Again, really want to encourage you to review the resources that we posted online. We also had a very extensive school discipline consensus report. In conjunction with these issues, folks have asked questions about school resource officers, school discipline. We have an extensive report that we published a few years ago that has a set of best practices and recommendations for jurisdictions along those lines. And then if you are a probation director, a policymaker, a judge or other who is really interested in reforming these issues and having your jurisdiction take a look at them, feel free to reach out to us and feel free to reach out to me directly, because certainly part of really getting this research and this message out there is wanting to see jurisdictions take some concrete action in this regard, and we'd be interested in partnering with you. So thank you all so much for your time, and we appreciate everything and hope you'll take advantage of the resources that we have to offer.